court-martial involving civilians must immediately cease.
The case traces its roots to the Supreme Court's landmark decision in Attorney General vs. Kabazuguluka, which banned the trial of civilians in the military court, citing lack of jurisdictions among other reasons. Among the civilians whose cases were pending before the military court were retired Colonel Dr. Besigye, Hajobedi Rutale, and Captain Ola Denish Oya, who had been charged with unlawful possession of firearms and treachery. Following the ruling, the Supreme Court ordered the Attorney General to transfer all civilian files to the Director of Public Prosecutions for further actions. Besigye's case was later transferred to the civilian court before Chief Magistrate Christine Nantege for trial.
And the Constitution grants all these rights. Look at Article 23. Article 23 is very, very clear. An accused person who is in detention has got a right to get medical treatment. Now that he has been formally arraigned and a remand warrant issued, and we are pursuing the bail process, he is calling off the hunger strike.
At this stage, the prosecution amended the charge sheet, dropping the charge of treachery and lawful possession of firearms, and instead charging Dr. Besigye, Hajobedi Rutale, and Captain Ola Denish with treason and misprision of treason.
On the basis of the investigations that we conducted with the police, these are the two charges that we found appropriate, and we found sufficient evidence or substantial evidence to sustain the two charges.
And if charges have, for example, the retired Colonel Dr. Besigye, would you go back to Greece? Would you go back to Switzerland? Would you go back to Nairobi? Would you replant a gun there? Because everything, the chain of evidence, everything about that charge was extinguished. It was destroyed because a DPP cannot rely on evidence of investigations by the military.
They asked the court to grant the accused a mandatory bail and nullify the proceedings, alleging that the accused had spent 180 days on remand. Although Chief Magistrate Nantege insisted on proceeding with the case, this prompted Dr. Colonel Besigye's legal team to file a complaint with the Judicial Service Commission, alleging bias and seeking the magistrate's recusal.
Now we are asking him, at the time when he was in Luzira under the remand warrant of the General Court Martial, what was his status in Luzira? Because Luzira is a remand prison. You can only be there either when you are in remand or a convict.
In the twist of events, applications for mandatory bail were filed before Magistrate Winnie Nancha Jetika at Buganda Road Chief Magistrates Court, and later before Judge Comfort Kania. All the applications were dismissed for lack of merit.
As much as the applicants are protected by the presumption of innocence, their antecedents must be considered. I have no guarantees that if the applicants are released on court bond, they will not engage in similar acts and therefore lead to new charges. It is my opinion that the sanctity and the authority of the court must be protected, and the court should not be sucked into the arena or the theater of politics. And on that basis, the application for bail is rejected.
By implication, it means once you have a case already in the court or a charge preferred against you and you are facing a trial on another charge, and once you are brought again before court, you are not entitled to bail. That's a very bad precedent. So this is a matter we are pushing to appeal, and right now we are going to start on the paperwork.
On the day scheduled for commutal to the High Court, the accused lawyers dramatically walked out of the proceedings, alleging trial by ambush and alleging bias by the presiding magistrate, then Esther Nyandoi. Despite the protest, court proceeded to read the indictment to the accused, a move Dr. Besigye unsuccessfully attempted to block. According to the commutal papers, prosecution alleges that Dr. Besigye, a former senior army officer, a founding member of the Forum for Democratic Change, used international meetings held in Geneva, Switzerland, and Nairobi, Kenya, throughout 2023 and 2024 to coordinate a plan to overthrow the government of Uganda.
Knowing that another person intended to commit treason, did not give information thereof, with all reasonable dispatch to the minister, an administrative officer, a magistrate, or an officer in charge of a police station, or use all reasonable endeavors to prevent the commission of treason.
Court further had that these meetings allegedly involved foreign operators, including Kardashian intelligence agent with whom Besigye is said to have discussed military trainings, sabotage, and a possible drone attack targeting the president. Prosecution also alleges that Dr. Kizza Besigye received $500 from AW to facilitate transportation of 36 Ugandans to Kisumu for military training. The group was arrested before the training commenced, deported to Uganda, and later charged with terrorism. While awaiting trial at the High Court, the accused filed another bail application before Judge Emmanuel Baguma, which was dismissed.
The offences are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offences alleged to have been committed only in Uganda.
Court also based on the ground that since the accused are facing offences which carry maximum sentence of a death penalty, called for no chance to release them on bail.
The interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offence, may fall prey to the temptation to interfere with the investigation.
He's interpreting the law mechanically and for purpose, for a reason, because he wanted to circumvent the provisions of Article 23. So we take exception to this. We are aggrieved, we are appalled, and we do not accept this decision.
They also filed a complaint with the Judicial Service Commission regarding Judge Baguma's conduct and lodged a petition in the Constitutional Court challenging alleged bias and seeking interpretation of the law.
Now that he has demonstrated bias, we have no reason to go back and forth. We said, no, let it now go to a different judge so that we can see if it's possible to get justice from a different judge.
The prosecution objected to these prayers. As prosecution sought to proceed with a pre-trial, the defense again asked court to hold proceedings pending ruling from the Judicial Service Commission and the Constitutional Court.
With the presence of all these many applications after applications which have been before this court, to have these amendments done before the matter is actually set for proceeding.
If prosecution has decided to keep quiet, then what is he doing? It's as if he's opening new matters.
The prayers were dismissed. In his ruling, Judge Baguma directed the accused to first take plea before reapplying for bail.
I am aware and alive to the constitutional right of presumption of innocence of the applicants until proven guilty. And in simple terms, retaking enables court to ask an accused person if he or she admits or denies charges.
As the court attempted to read the charges to the accused, the defense once again halted the pre-taking, citing defects in the indictment and alleging trial by ambush.
Indeed, this matter has been fixed for pre-taking today. It ought to have been preceded by service, copy, signed, and served on the accused person well in time.
Even if the accused wanted to open read, there is nothing to read to now as we speak.
I am urging the court, therefore, to put a stop to pronouncements that are likely to prejudice the hearing of this case.
The indictment, whereas the not yet been served a signed copy, the indictment does not, as read earlier, that it shall be handled today or the time when they are going to plead. It still describes the particulars of Captain Dennis Oya.
Judge Baguma overruled all the prayers, ordering the accused to take plea. Although all the accused declined to respond to the charges read unto them, this did not hinder Judge Emmanuel Baguma to record a plea of not guilty.
A1, Captain Brigadier Dr. Besigye, A2, Adjournment, and A3, RO 12743, Captain Kola, Benish Oya, and other still at large, are indicted with the following offences. In count 1, treason, contrary to section 23, 1C of the Penal Code Act, cap 1 to 8. And the particulars of the offence state as follows. Colonel Retired Dr. Besigye, Adjournment, RO stroke 12743, Captain Kola, Benish Oya, and others still at large between the year 2023 and November 2024 at various places and countries, including Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, Kampala in Uganda, contribute a plot, act or matter by force of arms to overturn the government of Uganda as by law established and expressed or such plot, act or matter by utterances and avert acts. The particulars of avert acts. A. Colonel Retired Dr. Besigye traveled to Geneva, Switzerland and attended a meeting on the 29th October 2023 with others, where he and others discussed a plot to overturn the government of Uganda by force of arms. B. Colonel Retired Dr. Besigye traveled to Geneva, Switzerland and attended a meeting on the 24th January 2024 with others, where he and others discussed a plot to overturn the government of Uganda by force of arms. C. Colonel Retired Dr. Besigye traveled to Geneva, Switzerland and attended a meeting on the 14th June 2024 with others, where he and others discussed a plot to overturn the government of Uganda by force of arms. D. Colonel Retired Dr. Besigye traveled to Athens, Greece and attended a meeting on the 29th September 2024 with others, where he and others discussed a plot to overturn the government of Uganda by force of arms. E. Colonel Retired Dr. Besigye and Haj Obed Mutale traveled to Nairobi, Kenya and attended a meeting on the 16th November 2024 with others, where he and others discussed a plot to overturn the government of Uganda by force of arms. F. Between 14th June 2024 and 24th July 2024, Colonel Retired Dr. Besigye solicited for and received $5,000 and applied the funds to facilitate a group of 36 individuals to travel from Uganda to Kisumu in Kenya in order to attend and receive training in furtherance of the plot to overturn the government of Uganda by force of arms. D. Between the 29th October 2023 and 16th November 2024, Colonel Retired Dr. Besigye RO stroke 12743, Captain Kola, Benish Oya, and others made various utterances on the WhatsApp social media platform where they discussed and expressed their intention to overturn the government of Uganda by force of arms.
We start with that count one. Is that true?
My Lord, before I say whether it's true or not true, I am really horrified. Horrified by the way things have gone today. The way things have been going. Because, my Lord,
I will give you a chance to say something, if you so wish. But at least let me first know on this allegation we have raised.
see, my Lord, you spent here the whole day arguing with the case that plead guilty or not guilty is a subject that requires advice. That's why we have all these high-level individuals.
I said, Doctor, I will allow you to say something, but let me know your plea on this count.
Yes, I'm saying,
yes.
How do you want me to plead
you
when you have cut out the highly needed advice of my lawyers as granted by the Constitution of the Republic of Uganda and by law?
I will allow you to say something, but let me know your position. If you are not pleading, it's okay. But you are not pleading.
I'm not in a position to plead without advice.
It's okay.
Simply not possible. Prosecution. It's not a prosecution. It's like I'm being tried by the prosecutors and the prosecutors I have faced for 20 years now. I've been charged with prison. I don't know how many times I've been charged with prison. Prison that never comes.
Doctor,
So
I'm
fed up with this persecution.
I am using section 63 and I have saying free of not guilty under section 63. Under section 63, I A, free of not guilty is
Yes.
Court will resume on 21st January 2026 for further hearing of the case.
I am using section 63 and I have saying free of not guilty under section 63. Under section 63, I A, free of not guilty is